Deputy Sean Conlan.
I welcome the arrival of this bill, which will enact various improvements to the administration of civil registration in this state. This amendment is broad in its capacity, but I find the changes made to the registration of marriage and civil unions of key interest. The right to marry is a fundamental right according to both the European Convention of Human Rights and the Charter of Fundamental Rights of the European Union. Article 41(3) of our own Constitution commits our state towards guarding the institution of marriage with special care. If all of these documents, which form the backbone of our legislative powers, hold the institution of marriage in such a high regard, it is important that we closely analyse any attempts to limit or regulate that right. Though the definition of marriage can become subject of intense debate, it is hard to imagine anyone encouraging the use of the institution of marriage for the purpose of circumventing our immigration laws and procedures. In a 2011 High Court ruling, the decision was made that a marriage contracted for immigration purposes is valid under Irish law due to the lack of explicit legislation against such practices. Allowing such a loophole to remain unchanged diminishes the authority of our naturalisation procedures. It is imperative to ensure that our civil registration process does not interfere with the work being done to accommodate and manage our immigrant population. By putting into place this amendment to the Civil Registration Bill, we can distinguish between those who want to use marriage for legitimate purposes and those who are attempting to manipulate the system. Our failure to legislate on this immigration breach has raised international concerns, particularly from Latvia. There has been a rush of marriages that were allegedly responsible for trafficking Latvian women to Ireland with the intention of marrying non-EU nationals for the purpose of citizenship. We cannot stand idly by and simply watch as Ireland is used as a haven for human trafficking. We cannot allow our own republic to become the weakest link for those looking for an illegitimate reason to enter the European Union. Most importantly, however, we cannot allow our negligence to affect the lives of vulnerable women from within the European Union. We must strive to make a positive difference through our interactions with Member States and making our immigration process airtight as part of that commitment. The issue here isn't marriages or civil partnerships based on economic benefits. While it may be optimal a situation where one is in love with their partner, it is by no means a legislative requirement. It is important that we keep in mind that all of the prospective situations in which one may find themselves before we pass laws which might infringe on the rights of Irish citizens to self-determine their own lives. Civil unions and marriages are not the only issues within the scope of this bill. In particular, Section 6 amends a great deal of legislation with regard to the registration of a child's birth parents. Over 35% of births last year were made to parents outside of marriage. In current law, only the mother's name need be registered in the circumstance of a child born out of wedlock. This unfortunately leaves a child without a guaranteed right to know who the father is, a condition which can bring great confusion into one's life through no fault of that child's own. It's also important to know where one's lineage comes from for practical reasons, such as establishing family connections and where they might exist. And this may be problematic if this information is not available. Of course, exceptions are to be made, and this bill does allow for some room for negotiation. Should a mother lack knowledge of who the father is, or should she find it to be detrimental to the safety or welfare of either her or her child, then she may opt out of this new registration requirement. This nuanced approach to birth registration ensures a fair and unobtrusive process be used when gathering what can be sensitive information that is necessary for a number of legal and administrative reasons. On this facet of the bill, it is important that the rights of the child be placed at the forefront of our efforts to navigate this potentially controversial amendment. Critics will rightfully point to the compulsory nature of birth registration as being somewhat unjust to women who find themselves in a position of potential vulnerability. It is not our responsibility as lawmakers to pry into the personal lives of our constituents, but for us to take our focus off the rights of the child in question would be a disservice to that child. Children born in this country have a right to know where they come from, and we must preserve their rights to their own identity above all else. In the terms of this amendment, I firmly support our government's push to streamline our civil registration processes. The more we work to sharpen existing legislation, the more efficiently and effectively we serve the citizens of our nation. Thank you very much.
Thank you.